Everyone, and welcome to the Academic Forum of the new university, which is today dedicated to the compliance with European Court of Human Rights judgments in Slovenia. My name is Matej Aubal. I'm a professor of European law and director of the new university, and I have a great pleasure and a great honor today to introduce to you Veronica Fikfak, who is a professor at the University of Copenhagen in Denmark, who is running the project, the project that I told you about, that is in the title of today's academic forum, and who is going to present to you her first findings that she derived in the project together with the guests that she invited for today's event. Without further ado, Veronica, the floor is yours. Thank you very much for choosing the new university for presenting your project, and I'm looking forward to working with you further in the future. Good luck.
Thank you very much, Matej, and thank you everyone for coming along to today's presentation. I wanted to first thank Matej for the invitation, but also especially thank our discussants who are going to speak after me, and we'll introduce each one of them separately later. But I've asked friends and colleagues from Slovenia, as well as from the Czech Republic, to comment on what we're seeing in Slovenia and really to provide a certain comparison in terms of compliance. So what I'll do is I will share my screen with you, because I've got a little PowerPoint of our initial results, and I'll also explain the project. But I wanted to sort of start off by saying that the report is now available both in Slovenian in Pravna Praksa. So I think it was maybe 2 issues ago that it was published in Slovenian, but it is also available now on SSRN in English and on our website. So if you go on our website, www.humanrightsnudge, which is the site of the of the project, you'll find the report there. So I'll share my screen with you, and I just want to check with people that it's being shared properly. Could I just check that that looks okay? Yeah, super. Okay, super. Thank you very much. So what we're doing, so I'm running an EU project that's essentially a 5-year project that looks at how different countries around the Council of Europe comply with decisions of the European Court of Human Rights. And it's a team project, and we're looking essentially at 25,000 judgments of the European Court of Human Rights, and then we're following them through into what different states do and what works and what doesn't work. So in that context, one of the first countries that we've taken into consideration is Slovenia. Now, why did we take Slovenia? Why we wanted to study it? There's a number of reasons, obviously. One of them is that Slovenia is really, when you look at the percentages of compliance with judgments, it's one of the best countries in terms of complying with judgments of the European Court of Human Rights. So, oops, there you go. So you might wonder why I chose to do this project, right? So the project tries to really go and look at when countries comply with judgments of the European Court of Human Rights. So what we're trying to do is we're trying to identify best practices around the Council of Europe. So when have countries actually gone and changed legislation or changed their internal practice in response to a decision of the European Court of Human Rights? And we're specifically interested in this because about 50% of all of the judgments of the European Court of Human Rights remain unenforced, which means that they are just words on paper. And so we wanted to see when that changes and whether or not it's specific to specific countries, or whether or not we can identify certain patterns, certain incentives that would work for countries to really change their behavior. So I wanted to start off with this slide, really, that shows how well Slovenia compares to other countries of the Council of Europe. And we've split the countries into what we call old countries and new countries. And old countries are the countries that really participated in the establishment of the Council of Europe. And the new countries are the countries that joined after 1990, so after sort of the events of 1990s. And Slovenia, if you look at this graph, is really at the top of the new countries that joined after 1990. Only a couple of countries rank better, and that's why I've asked Professor Kosar, who's from the Czech Republic, to comment on how Slovenia compares to the Czech Republic and see whether or not there's things we could learn from the Czech Republic to be even better. But I wanted to start off by saying that Slovenia currently has about 96–97% compliance rate with judgments of the European Court of Human Rights, which puts it really at the very top of the compliance scale, if we look at it, with, for example, Azerbaijan, Russia being at the very bottom, but you have also some other countries of, let's say, the previous or former Yugoslavia from the Balkans who rank much lower. Now, it's important to underline that this didn't always used to be the case. So if I had run this project maybe 5–6 years ago, those numbers wouldn't be so high and the compliance rate wouldn't be so high. And I'll explain why that is the case later. But it's important to think about compliance as a moment in time. And at this point today, Slovenia is a very good complier. But something happened in these last 10 years that have made it so. And we'll discuss that later. Now, Slovenia, so when we were looking for which countries to analyze, one of the really important things, because this is a big quantitative project, was that we wanted to identify countries that have a sufficient number of cases that we could actually analyze statistically, and that we could pull out analysis and certain findings from. And Slovenia is one of those countries. So it has 346 cases in which it was found in violation of the European Convention on Human Rights. Of these, I should say that about the majority, really 264, are related to what we call the Lukenda cases. So the Lukenda cases are cases that are related to the delay in the length of proceedings in domestic courts. So when domestic courts take a long time, what an individual can do is they can turn to the European Court of Human Rights and say, this is taking too long for me to get justice. And those are the Lukenda cases, which we sort of analyzed together in a group. So if we look at the Slovenian violations, let's say the violations of Slovenian, of the convention, if we look at them according to different group rights, which is the way we analyze rights, those rights would relate to physical integrity, so torture, right to life, personal integrity, which is freedom of speech, maybe right to private life, and then procedural rights. And this is really procedural violations, because of Lukenda, are really the violations where Slovenia has thus far sort of been at the top of the scale. So that's where most of the violations are gathered. But in terms of physical violations, so those relate mostly to one of the first cases against Slovenia was Rebok related to police violence against an individual. But we've also had cases that relate to poor conditions in prisons. And that is not only specific to Slovenia. There's a number of European countries currently that are struggling with that issue of having enough space for prisoners and where to put them. So those are the type of cases that have come against Slovenia in front of the European Court of Human Rights. And I want to be very clear that we're looking at all 20 years, so from 2000 onwards, we're looking at all of the case law. And so what I'm going to give you is really an overview of how Slovenia has behaved in response to these judgments of the European Court of Human Rights. So what's the goal of the project I'm running? So what we're trying to do is we're trying to understand first what the court, once it renders a judgment, what it expects of the country. So in most cases, it will ask for a certain amount of money to be paid, so what we call compensation. But in other cases, it might also ask for specific action. Now, that's not always the case. Sometimes the state will volunteer to undertake certain specific action. But we're looking at whatever is being undertaken, whatever measure is being undertaken in response to a decision of the court. And then we take that judgment and we follow it through into the state, and we look at what happens to it within the state. So how does it travel around? And who within the state, the government, which ministry is responsible for ensuring that it gets complied with? And we're specifically interested in the different branches of government, right? We're interested in the judiciary, the executive, but obviously also the legislative branch. When do these intervene? And one of the important things to remember is that whether or not something is complied with is the decision of what I call in this picture the CM. CM is the Committee of Ministers. So the Committee of Ministers is a body, a supervisory body of the Council of Europe that decides whether or not a country has undertaken enough measures to prevent this violation from happening again in the future. And so for us, that relationship between the state and the Committee of Ministers is really important, and we're trying to understand it. So this is the picture we are studying. And specifically, we want to understand how different remedies, and what do I mean by that? I mean, how compensation is complied with, how individual measures are complied with, and how legislation is passed, or what we call general measures. And in that context, we also want to know who are the most important actors in the process of compliance. So what did we do? We looked at 2,500 different sources. And essentially what that included is reports from that Slovenia sent to the Committee of Ministers. We looked at the government's website. We looked at judicial practice of Slovenian courts. And we also looked at different law reviews. So Pravna Praksa here was a really important source for us to understand what gets reported on and what gets followed up. And finally, what was really helpful is we conducted interviews with people responsible for compliance and with members of NGOs. So what did we find out? So this is really the first sort of slide that I think contains one of the most interesting results from our study. So the most frequent remedy that Slovenia is asked to implement or to undertake in response to judgment is compensation, which means the payment of money to the victims. On average, that compensation is about 7,000 euros. Most frequently, an individual will get 4,200 euros in response to a judgment. So in total, what Slovenia has paid is 2.54 million euros in response to what the court has told it to do. It would be misleading to think that this is all that Slovenia has spent on complying with ECHR judgments. So domestic compensation schemes have had to be set up in response to Kuric and in response to Alešić, so the big two cases. And those have really been expensive in terms of costing a considerable percentage of the budget, of the Slovenian budget, having to be dedicated to the payment of that compensation. And I've put the numbers that we think, or that were reported on that slide. So we need to think that the compensation that Slovenia is being told to pay by the court is not the only expense in terms of paying the victims, because there may be a number of victims inside Slovenia that after the judgment turn to the authorities and ask for compensation. The other thing that we found, and I want to underline this, is that traditionally it took quite a while for an individual to get paid the money. So on average, we found 735 days. But again, and I'll come back to that later, this has considerably improved after year 2015. And there's been a very big shift on how quickly you get paid. But on average, that's the number of days, so about 2 years, I think. Now, I've also put a graph on this slide. You'll see the little yellow dots. And what this graph does is, one of the things we've tried to understand is whether or not countries are sensitive to the amount of money that they have to pay, right? So we wanted to understand whether or not the amount makes a difference to the speed of compliance. And what this graph shows is that the higher the compensation is, the less time Slovenia takes to comply with it. Now we've checked this and double checked it and triple checked it, because we've received pushback when we previously presented this, that this can't be the case. But whatever we do with our statistical models, this remains the sort of conclusion we have, that Slovenia is a country, at least as far as it looks like it, that is sensitive to how much it needs to pay. And the way economists would analyze this is they would say that the same way that individuals are sensitive to paying more rather than less, and they might perceive more as more of a punishment rather than less, the same way it looks like Slovenia might be as well. But this is on the basis of the data that we have. So this is sort of the first set of results in terms of compensation. Now, in terms of individual and general measures, there's a number of things that Slovenia does in response to a judgment. Now, individual and general measures relate to how big or how small the measures that are taken are in response to a judgment. So individual measures will aim to redress the position of the individual. So for example, Slovenia will reopen proceedings, it will investigate, it will release people from prison, things like that. General measures relate more to the issue of trying to prevent similar things from happening in the future, right? So you might change case law, you might issue practical guidelines, and those are the kind of things that were needed in response to the Lukenda judgment, for example. So in response to the Lukenda judgment, you had to increase capacity, the number of people who would work at a court or inside the judiciary to help speed up the processes. In relation to a number of other cases like Shilik or LM, I think, you had to adopt the Mental Health Act or the Patients' Rights Act. So there was legislation that was passed to prevent similar violations from happening in the future. And here our aim has really been to understand not only what the country does, but what the Committee of Ministers that I presented before thinks is enough. So when is that body, that supervisory body, that's really, in some sense, a political diplomatic body, when is that body happy? And so what we've tried to capture on this graph is essentially, so all of these cases that are on this picture have been closed. So the Committee of Ministers has said that Slovenia has done enough to comply with decisions of the European Court of Human Rights. But when we looked maybe a bit more deeply to understand whether or not some of these cases could be potentially still a problem in the future, we found, and here I'm really talking about the middle group, that there still could be a problem of a similar nature in the future. And I'll talk about Lukenda as an example. So Lukenda has related to how speedy the proceedings are at home in Slovenia, right? And there have been enormous progress made in that context. And courts have really worked on this, and judges are, I imagine, very overburdened, but they're also compensated for or promoted for working very hard and speedily. Now, one of the things that has been noticed in terms of speeding up domestic processes is that there's been considerable progress made in terms of the speed of certain types of proceedings. But there are other types of proceedings where that problem of delay is still present. The other option, the other case that I could mention are cases relating to prison conditions, which have already been closed, but there are new cases that will arise because we have too many prisoners in too little space that might arise in the future. And Slovenia had plans to build a prison, but that has not yet happened. So there's a number of these cases where implementation or compliance was temporary, or it was for a certain time frame. But then what it shows is that actually structural systemic changes are sometimes very difficult to undertake and to keep sort of in force for a long time. So we are really going beyond when the Committee of Ministers is happy. We're also looking, does the process that a country has undertaken stop future violations from happening? And there's a number of areas in which it does, but there's also a number of areas where, you know, we need to see what will happen in the future. So that's sort of our second aspect of the study. And then our third aspect gets me really to who, to the actors, right? To who is really driving compliance at home, and who are these very active authorities or organs, institutions who are pushing this process forward. And I really want to say that, so this picture is based on our analysis of written documents. So what we've done is we've essentially looked at all the documents submitted to the Committee of Ministers and all the names that were mentioned there in terms of being involved in the process of compliance. Then we've looked at the media reports, and this is the picture that comes out. And so what this picture tells you is that you've got sort of three branches, right? The green one are the executive. Gray is National Assembly, so that would be the Državni Zbor. And then you have the orange, which relates to the judiciary, how the judiciary really gets involved in the process of compliance or in responding, communicating with the European Court of Human Rights. And then you've got the purple, which are the legal writers, the legal law reviews, right? Pravna praksa. And the blue are the NGOs, which absolutely form part of this picture. And so one of the things, so we've mapped this out, but as we look deeper and deeper, and as we talk to people, one of the things that became really, really important or really clear is that in these 20 years, there was a key date when things changed and when this picture really took this position. And that was in 2015. And in 2015, I'll just describe what happened. So in 2015, a decision was made to take the issue of compliance implementation from the context or from the jurisdiction of the state attorney's office into the Ministry of Justice, and to create this so-called project group or working group, project group, Projektna skupina, who is really responsible, who's the hub, the center of the coordinator of all compliance activities for Slovenian cases since 2015. And I wanted to show you because in our analyses, this really came out as super statistically significant. 2015 really comes out as this big different year. So if you look at this graph that I've put up, it shows in green, first the year the decisions were rendered by the court, right? So that's the green line. And you'll see that the majority of them, the Lukenda judgments, are rendered in 2016. And then the money gets actually paid in about 5 years, and let's say in the majority of judgments. But the moment when actually judgments get closed, and what I mean by that is when the Committee of Ministers is happy to say Slovenia has done enough for us to stop the supervision of these cases, that's the year 2015, 2016. And there's a direct link between the creation of this project group and the two ad hoc groups that really preceded it, and this shift in how things are handled at international level, but all, as a consequence of how it's handled on domestic level. And so what's come out as very clear from the interviews is that the moment the question of compliance became centralized domestically in one body, the communication with the Committee of Ministers also became more, I want to say, organized, more structured. So it became clear what Slovenia had to report, what kind of measures it should take, And that dialogue with the Committee of Ministers that perhaps was different before became informative and helpful to Slovenia to know how to get things done faster. And so the next graph that I'm showing really shows that big change. So if you look at these two lines, they show how long decisions rendered in 2005, 6, 7, how long they take to comply with, so close, or how long they take to be paid. And it's really from 2015-16 that we get into those small numbers that are actually within the time limit that the court sets for payment, and then that are quite quick in terms of the closure. So what we've learned from the Slovenian example, and here I'm talking as someone who's researching Slovenia as one example, but also looking at a number of other countries that might not have such a great compliance rate. What we've learned is that even in a country where, so in 2014, 2015, Slovenia's compliance rate wasn't great. But even in a country when compliance rate isn't great, if there is motivation, if there are the relevant people in position who make compliance their priority, and they have the power to sort of centralize the issue in one body, that body and people who we talk to are extremely dedicated to making sure that Slovenia's reputation on international level is protected, that it's good, that it's positive. So if you look at all of that together, it becomes very clear that when there's a will, there's a way. You just need to enable a certain group to do so, and you need to give them the space and know-how to do so. So we were actually, from our position, I was absolutely delighted to see that there is this interest, that there's this push, there's effort, but also that someone was enabled to do this, and that now the Slovenian picture looks very different. So I'll just conclude again with this picture, because I think this is one of our major discoveries that maybe came out of statistics, but then when we talked to people, we understood it better. The important thing to underline is also that although a lot of changes happen in the green, in the executive branch, that an important role is also played by NGOs, right? And that became clear. NGOs who talk to the Committee of Ministers, report to the Committee of Ministers, and create a sort of an energy that can sometimes facilitate compliance. So I'll stop there, and I'm obviously looking forward to the comments by the three discussants, but I wanted to say that our paper is available both at Pravna Praksa and on SSRN or our website, and that you feel free to get in touch with us, because this is really the initial results of the study that we're then mapping out onto Europe, and then obviously proceeding to compare Slovenia to other countries. But we're still talking to a number of people in Slovenia and would love to hear from you. So I'll stop there, and I will ask, if I may, David Kosar. David, could we have you on camera? Thank you. So David is a professor at Masaryk University in the Czech Republic, and he has done his own study of compliance in the Czech Republic, and Czech Republic is, I'll say, I think it's 90% or 98%
yes, that's exactly
compliance rate. So higher than Slovenia, but he's also written this wonderful paper in the European Journal of International Law that talks about how do we analyze compliance in good compliers. And so I really wanted to have his feedback on what he thinks about our report. And so I'll give the floor to you. Thank you very much.
Okay, thank you very much, Veronica, first of all, for inviting me to engage with your research, which is super interesting, and also for sharing an extremely interesting report on Slovenia. So I guess perhaps I would start with showing some, differences and similarities between the Czech Republic and Slovenia, at least as I might see them, but I would like to double check with you that this is actually the case, because you are of course much more much better, you know, versed in the situation in Slovenia. Then I would move to some, you know, bigger points concerning, you know, compliance and the limits of the concept itself. So first of all, it seems that, you know, both Slovenia and Czech Republic, they are having very high compliance rate, at least formally. But both from our research and your research, it seems that also there is a bit of a problem with internalization and institutionalization of the key principles and the case law of the Strasbourg Court. Not necessarily in these, you know, technical, you know, procedural issues, but in especially in some, you know, value-oriented issues decided by the court. And here I would like to double check with you, because it seems like that the majority of violations are procedural, but there were some, you know, big cases rendered against Slovenia that seem to me to a great extent very, you know, peculiar to Slovenia. And my question would be whether any of those cases was, you know, in a sense of sort of a scale like DH versus the Czech Republic, which is about the mass segregation. And it's a super big case about indirect discrimination that, you know, other states care about, especially Nordic states within the Committee of Ministers and exercise a lot of pressure, because that might be very interesting to see how let's say, you know, the old institutional framework and perhaps also the new institutional framework, this project working group would work with such difficult case, which is not about, you know, pecuniary damages or something like that, but requires, you know, really wide scale remedies to be adopted. Then it's also very interesting that I saw in your report that there seem to be some examples of judicial resistance in Slovenia. I guess it was this Copernica case. So it was not the case in the Czech Republic when we wrote the paper, but there has been, you know, growing dissatisfaction with some of the Strasbourg case law, especially regarding the transgender people, and already Supreme Administrative Court went clearly against the Strasbourg Court. The case is pending before Constitutional Court. So it seems that traditional allies of the Strasbourg Court might be fighting back, which is an interesting phenomenon taking place in Central and Eastern Europe, and we are still talking Slovenia and Czech Republic, and not Hungary and Poland, where some of the courts are really, you know, clearly captured. But I guess the Slovenia and Czechia are still doing much better. It's very interesting to see sometimes also the reasons behind this judicial resistance, because that might be interesting for you since you are covering, you know, Slovenia as your first case study. That one of the first examples of judicial resistance in the Czech Republic took place when the Czech Supreme Administrative Court rejected Grand Chamber judgment in Zolotuchin versus Russia regarding the ne bis in idem principle. And the interesting story behind that is that it was after the former Strasbourg judge, Boštjan Župančič, visited the Supreme Administrative Court and basically told all the judges that Zolotuchin is a nonsense. They had a debate and they agreed that it is a nonsense. So the judges, you know, decided to not comply with this judgment. So sometimes, you know, these tiny things matter. And it also brings me to perhaps a broader point, which is not in our final EGIL piece, but was in one of the, you know, earlier submissions, when we think it's also very important to look at the Strasbourg rulings and check to what extent the reasoning is persuasive, to what extent it is novel. Sometimes the number of dissenting opinions matters as well. It's already been empirically proved, I guess, by some of your colleagues at ICORS. You know that very well. And regarding, for instance, the DH versus the Czech Republic, I think the big trouble was initially the lack of clarity of implementation steps. So it was not really clear what's required from the Czech Republic. Is it just, you know, to change the legislation and abolish, you know, the special schools, or is it actually about, you know, changing the society in a sense and reducing the number of Roma children in certain schools, which is extremely difficult due to the you know, pushback and resistance of the parents and all sorts of, you know, other actors that states has no chance to force them to comply. If they see that the school is problematic for their kids, they will just, you know, move them elsewhere, and you can't do anything about that. So, and sometimes also that's the recent transgender case, I guess, implicitly, whether it is a chamber ruling or a grand chamber ruling, is also very very important issue to be taken into account. Of course, I do not know into such detail whether this might have been relevant in some of the Slovenian cases and in compliance with them. But that might be the case. Then I very much like your empirically justified and evidence result, basically that the higher the compensation, the faster the payment of the Slovenian state, which is going sort of against, you know, the general understanding how the things work. It would be nice to see some hypothesizing or theorizing why this might be so. Is it in terms of an article, does it mean that perhaps, you know, if there is a higher if there are higher damages awarded, it means that it's a more severe violation and the reputation of the state might be at stake internationally, and therefore it's, you know, better to get it settled soon rather than, you know, being discussed within the committee of ministers and so forth. So it would be nice to know what's going on in this. Then regarding the difference between compliance and implementation, that that's also a very important distinction. In our recent book in Routledge regarding, you know, the use by the Strasbourg case law by Czech courts, we use the word judicial treatment basically to distinguish it with compliance, because it's often viewed in binary terms, even though it's more of a continuum, but it's far more complex. Here, I have just one small suggestion. It seems to me that research by Andreas Verstaden on minimalist compliance would be very interesting to integrate here, because there are clear incentives of the state to have the case closed and to show some good faith, but at the same time not to do too much, which is, you know, why we need the NGOs and the civil society to show us the other side of the coin. Then regarding the domestic actors, I guess here Slovenia shows also quite some similarities to the Czech Republic, where the so-called College of Experts concerning implementation of Strasbourg judgments was established at the Ministry of Justice as well. All the ministers are sending their representatives, the civil society, academia as well. There is strong, you know, sort of, you know, coordination there, and some issues can be discussed internally. The question I'm having is basically what role in Slovenia plays the government agent, whether he or she is to some extent involved, because this is not often addressed in the literature, and their roles vary a lot. Sometimes they are assigned to Ministry of Justice, sometimes to the Ministry of Foreign Affairs, sometimes to another organ. Sometimes they are important and influential people in the Czech Republic. Perhaps, you know, the high compliance rate is to great extent dependent on the person who is the government agent right now, because he has been there for 20 years, so he's having institutional memory, all the connections and so forth, and people listen to him, which might not be the case in many other jurisdictions. The other question is whether the project working group, why it was established at the Ministry of Justice and not elsewhere, and whether you think that it would work the same way had it be at other ministry, or basically to attach to another organ. Because it seems to me that the major breaking point was the project working group, and perhaps, in my opinion, as I see it from what you wrote, not the fact that it's at the Ministry of Justice. So perhaps that could have been done elsewhere. So I would like to know more why it was attached to this ministry and whether my assumption is right. And then perhaps my bigger point would be that it would be great to know, and I guess you mentioned in the report briefly, what was the political environment around 2015 that allowed this project working group to take place, to get this funding, get this, you know, coordination potential, and get this leverage over other organs, I guess, apart from the courts, to improve compliance as well as implementation of Slovenia with the Strasbourg rulings, because it seems that the foundations of implementation and compliance are often political, and the domestic actors in this are crucial. So in terms of our EGLPs, I'm just wondering whether that was sort of, you know, window of opportunity, given, you know, the specific setup and situation on the Slovenian political scene that allowed this project to take place and get it up and running, or whether there was some kind of different logic, sort of, you know, gradual understanding that, you know, this should be centralized, made more effective, and whether there is any opposition to this new trend that's going on in Slovenia. I have some other comments as well, but I guess I would stop here so that I leave the floor to others as well, and I'm looking forward to your response.
Thank you so much, David. Thank you so much. I will ask Professor Jernej Letner if he can go next. Jernej?
Hello, I'm here.
Thank you, super. So I've asked Jernej to provide comments as well, because he is actually one of the commentators that, when we were looking at you know, who has written on implementation of decisions of the European Court of Human Rights in Slovenia, Jernej is really, I think, in terms of consistency, one of the scholars that appears most. And so I really wanted him to sort of give his thoughts on the initial report. So the floor is yours, Jernej. Thank you.
Thank you very much, Veronica and Ula. It was a pleasure reading your article. I'm also following your other publications. I'm always happy to comment, and it's super interesting. It also is very close to my heart. I have been following this area of compliance here in Slovenia, but also beyond in Central, in Eastern Europe for the last 10 years. And I will structure my comments in three parts. First, briefly just mention this relationship between the European Convention, European Court, and the Slovenian constitutional system. Then I'll talk a bit about how the actors, you know, particularly I will focus on judiciary, implemented or they have not implemented some of the judgments. And then thirdly, I will ask, I will refer to one issue already David mentions the notion compliance. What do we really mean by the notion compliance? Is the judgment of the European Court of Human Rights really closed when the Committee of Ministers decides so? As we know that governments, not only Slovenian, they just want to have this, the feature, the sign that the case is closed. Is the case really closed after the Ministers decides that it's closed? No. But let me start first with the relationship between the European Convention and Slovenian domestic order. Well, and I'll focus here my comments on judiciary, on judicial branch of government, and I agree with you, Veronica and Ula, that executive branch, but also legislative branch, they have done immense work in the last 5 to 6 years in implementation of the judgment. I'm a bit more skeptical and reserved as to the role of the judicial branch. I'm not sure that Slovenian courts have properly internalized the judgments and the values of European Convention. Now, in Slovenian domestic legal system, it's very hard to implement a judgment of European Court of Human Rights. No, in the legislation, only law on criminal procedure allows for legal basis for opening procedure. We don't find such legal basis in the law on civil procedure or law on administrative procedure or on execution procedure. No? So there's no legal basis really to enforce individual measures in our judgment concerning right to fair trial in the civil proceedings. Victims, rights holders, they're often left without options, apart from compensation. Of course, Slovenian Constitution says in Article 8 that judgments and international treaties have to be directly applicable in the Slovenian national legal order, but often when I read the judgments by Slovenian ordinary courts, they don't really refer to Slovenian Constitution. So this is often a problem, how to adopt individual measures in a particular case where European Court of Human Rights found violation. And here I want to mention 3 cases which you also mentioned in your article. The first case is Copernica case. Copernica versus Slovenia case is a case where the European Court of Human Rights found a violation of Article 7 of European Convention concerning legality principle, and the complainant, upon receiving the judgment in his favor, started reopening proceedings. He requested the reopening of proceeding on the basis of a Criminal Procedural Act, and then the Supreme Court again discussed the case. And when one reads the judgment in the Copernica case, one finds really some very interesting quotes. If somebody is interested more in detail in that, I wrote an article, quite long article on that in a Pravosodni Bulletin some years ago. It was published. For example, and I can quote some of the sentences. For example, the Supreme Court said that judgment of European Court of Human Rights are not directly applicable in Slovenian national legal order. It said, for example, also, and here again I quote, that there is a difference between the judgments of European Court of Human Rights and national judgments in that national judgments are binding, whereas the judgment of European Court of Human Rights are usually non-binding on state parties. End of quote. And those of you in Slovenian audience, you may remember some years ago the leadership of the incumbent leadership of Supreme Court said that they do not really feel themselves bound by the judgment of European Court of Human Rights, and that they will choose whether it's appropriate or not to implement a judgment in a particular case. In this case, Copernica versus Slovenia, the Supreme Court of Slovenia totally disregarded the judgment of European Court of Human Rights. They did not follow it. They did not engage with the judgment. They did not sustain why they're deciding differently. They didn't provide the arguments for a different decision, and they, again, for the second time, they rejected the case, the complaints by Mr. Copernica. And some of you will notice that there is a quite rich discussion on the compliance and judiciary with the judgments of the European Court of Human Rights. And you will remember judgment against the Portugal. It's a case called Moreira-Ferreira versus Portugal, second judgment, where the European Court of Human Rights said that the national courts can differ with judgment of the European Court of Human Rights if, and I quote here, they do not distort or misrepresent the judgment delivered by the court. End of quote. And here the Slovenian Supreme Court did not really, as I said, did not really explain why their reasoning is a bit different. And it used I found really interesting phrase that Slovenian Supreme Court wants to have a judicial dialogue with the European Court of Human Rights. They use this phrase, judicial dialogue. And then I was thinking, well, judicial dialogue, it's a Supreme Court, which is under the Constitutional Court of Slovenia, and European Court of Human Rights is then above both courts. Can Supreme Court really have a dialogue with the European Court of Human Rights? Well, my position, it can, as the court itself said in the Moreira versus Ferreira case, but only if the dialogue is reasoned. So in this case, the complainant, again then complained to the Constitutional Court of Slovenia, and the case is pending before Constitutional Court of Slovenia. But to show you how the situation is really complex, the Committee of Ministers, already closed this case. It says on the webpage, case closed, main measures were adopted, individual general measures were adopted. And here I quote, is a very interesting quote from the status of execution. I quote that the Supreme Court held that its decision was deprived of any arbitrariness in regard to the context of applicable national legal framework and ensuing possibility of obtaining different outcome in the given case. End of quote. So it seems that the really Committee of Ministers did not really engage with the decision of Supreme Court, that probably the case was closed as the representatives of Ministry of Justice of Slovenia lobbied within the execution department and at the meeting of a ministry of the committee of ministers. So here my point is, are really the values of European Convention internalized in the Slovenian judiciary, or it's only rhetorics? Only on a rhetorical level, one is committed to the European Convention and judgments, but then when there is a concrete case, you don't really engage with the case, you reject it, and then the complainant again is before the Constitutional Court, and probably he will, in a negative outcome, also in the second case, resort to the European Court of Human Rights. So this is one case. Second case, which I want to refer just briefly, that I don't take too much time. It's a case from many years ago. It's called HIT DOO versus Slovenia. It's a case where European Court found violation of right to fair trial because the same person, a Constitutional Court judge, was involved in a case, whereas she was already deciding the same case when she was a judge at the High Court in Maribor. And just recently, a week or 2 weeks ago, we had exactly the same case. Facts very similar, prohibition, violation, prohibition, conflict of interest. Constitutional Court did not exclude himself from the case where he already decided the case at the lower stage. So again, the question is about internalization of values of European Convention. And then the third point is concerning Shilik versus Slovenia. The audience will remember that this is one of the most notorious cases against Slovenia concerning the medical negligence. The case was settled, in 2016, if I'm not mistaken. And I was recently researching for another article what is going on in this case, whether this complaints procedure in case of medical negligence was established within the Ministry of Health, Ministry of Justice, and all of what I could find was information from 2017 and 2018. There was no updates. So again, my point is whether is it only formal compliance, or it's a change in mentality, in internalization of values because of the judgments of European Court of Human Rights. And before I finish, just the third point quickly, the role of Committee of Ministers. And here, Veronica, perhaps if you did research also in other countries, I would like to hear, is the Committee of Ministers really appropriate body to consider the compliance with the judgments? No? Because we know that it's a body made of diplomats supported by officials of the Council of Europe. So is the case really closed when the Committee of Ministers decides that it's closed, even though that we know that cases which were considered to be closed before the committee then ended up for the second time before the European Court of Human Rights? What should be the role for the Committee of Ministers, and how can the European Court of Human Rights perhaps even further improve supervision of compliance with the judgments of European Court of Human Rights? So I'll stop here. Thank you again, Veronica and Ula. I enjoyed your article. I will follow your research further. Thank you.
Super, thank you so much, Jernej. Lots to think about and to respond. But before, I will turn and ask Professor Sasha Zagorc, who's an expert really in the field of human rights. And we've asked him really to give his view on how he feels our report fits within also the research you're doing in the Slovenian arena that you know well. Thanks, Sasha.
Thank you very much, Veronica. First of all, congratulations to both of you, with Ula, for a succinct wrap-up of the analysis of the Slovenian implementation. It will definitely serve as a welcome reading material for my students at the European Human Rights Law class. This is really something I'm really looking forward to disseminate. But as a start, I would like to say it's always worth reminding that the execution of the European Court of Human Rights judgment, or the more general implementation of the judgment, if successful, are still belated remedies for a series of failures on the side of state authorities. So this is my value judgment I would like to start with. In a way, it's an unfortunate sign that internal national capacities to avoid, detect, resolve, and remedy infringements of the conventional rights are inexistent at worst or significantly weak at best. So the issue that we are discussing today may arise in other contexts as well. So I would first like to broaden up a little bit, just to get a general view, and then I will stop with this. So how relevant stakeholders understand and implement the EU Charter on Fundamental Rights and national constitutional case law in national legislation, for national legislation, executive measures and judicial decisions, is, in my opinion, also a precursor of the manner and the quality of implementation of the European Court of Human Rights case law in national setting. At least for Slovenia, in my opinion, examples that may confirm an Achilles heel of the Slovenian understanding of the rule of law in these regards are telling. For example, years-long non-executions of a number of decisions of the Constitutional Court, and etc. So, just briefly, I would like to ask Veronica and Ula for a very brief answer, whether these parallels are relevant for the research, or should we analyze them separately? But let's be now more concrete in my comment. As an ex-member of the ad hoc committee on the execution of the Alish judgment, the one that Veronica already mentioned in the introductory presentation, I would like to present a specific and very positive example in light of Slovenia as an exemplary complier, as the title of the article suggests. So, and by this I will also be able to at least partially answer what David was raising as an issue. What was the logic behind this weird correlation between the speediness and the amount of just compensation needed to be paid? So in the article, Veronica and Ula analyzed how implemented measures affect the speed of execution of a judgment. In the Alisic and Asadja case, according to our approach at that time, the state successfully reversed this logic by pursuing a speedy execution of the judgment in order to widen the margin of appreciation in other aspects of the execution. In other words, deadlines for the repayment of savings were in this case less relevant for Slovenia than the ominous interest rate. So our logic was put more effort to lower interest rates by, of course, giving some kind of a carrot to the Council of the Minister and, of course, individual applicants in order to internalize this approach and accept it as satisfactory for the processes of supervision. Second thing I would like to raise is what ENA already started. In line with his remarks on some aspects of judiciary and the quality of judicial internalization, I would like to point my criticism in the direction of the legislative bodies and the political environment, the one that also David highlighted as well as relevant for the research, to find some background underlinings and so on. So in my opinion, the res interpretata principle encourages also legislative national authorities to study the full body of the court case law for principles to be applied in domestic legal order, with the goal of preventive anticipation of possible violations and to integrate convention standards into the legislative process. However, as I've seen the reality, we have witnessed egregious examples of opposite view to this on the side of high-ranked politicians and civil servants. For example, that it is the role of only the constitutional courts to provide answers on the constitutionality of a law. This was said by then minister, also a professor of law, which is of course even more surprising. Another reproach relates to the incessant negation of the necessity to implement the Courage and others pilot judgment, where a lot of high-ranked politicians are still, even now, even after the implementation of the judgment, are still denying the relevance of this judgment and the necessity to, of course, remedy all the wrongdoing. In my opinion, such regressive standards go contrary to the incentives that the European Court of Human Rights gives to the state by tolerating, as Arnar Dottir would say, enlarged margins for diligent policymakers. But still, okay. But now, for my last third part, I would just like to raise what Veronica specifically asked me, and this is whether I am able to address a specific perspective of the compliance and implementation of the judgments, namely in the sense of importance of studying compliance and thus the crucial role that the legal education and educators play in this context. So, as it was emphasized in the article, and I fully agree with it, a proper execution of the political sensitive judgment requires a good mixture of legal understanding, political savviness, and diplomatic skills. So let's address this, whether some, let's say, education in broader terms could actually produce some positive outcomes, and then of course we will in the second part address education and scholarship in narrower terms within the legal academia. First, in broader terms, in my opinion, of course, education of main political stakeholders is a prerequisite, at least from the Slovenian perspective. I would really like to see that we try to build more in the sense of giving capacity to political figures to respect the conventional standards. I gave you some examples where this was not met and all the negative consequences are visible. In addition to this, of course, what I find really useful is that there should be learning process for public servants in this regard, especially those who are heavily invested in the process, in this process of implementation and, of course, execution of judgment. And I can give you one fine example. An LLM thesis made by Matthias Marko, who was a secretary within the Ministry of Foreign Affairs, and he was a secretary of the ad hoc committee, and he actually, by being part of the Alisic and Sajak implementation process, he actually gained theoretical knowledge, and of course he tried to make a lot of synergies out of it in theoretical terms and in, of course, practical implementation terms. The next thing is something that already Jerne mentioned, and it's not something that it couldn't be stressed too much. Of course, it's about judicial training. In my opinion, there should be some standards, of course, and it's a nice wordplay. By internalizing the convention standards in judiciary, we could be able to de facto prevent internalization of the dispute. So, yeah, these small steps in judiciary could actually, and in the long run, give the state even better results at the end. Further, concerning public and NGOs, I believe awareness campaigns are necessary in that regard, in order to foster the environment where acceptance and remedying of wrongdoing is a standard, and of course by pushing politicians in that regard, of course NGOs and civil society can actually do a lot. Of course, now finally, legal education stricto sensu at the faculties of law in Slovenia, and allow me to limit myself only to the situation at my alma mater. Does the current educational setting suffice for, let's say, lawyers that enter the legal market, and if they would apply for some kind of a job at the Ministry of the Foreign Affairs, the Ministry of Justice? In my opinion, according to my understanding, what are educational goals and needs, I would say yes. First of all, I believe there are three goals that we would like to achieve. One is, let's say, give some pluralistic views on what are, let's say, some values which are the ones which should be enshrined and the ones where pluralism prevails. Then, of course, we need to provide theoretical knowledge, theories, and lastly, to a certain extent, I would even say skills. So at the Faculty of Law, where I teach, of course, we have European Human Rights course. It's an elective course, but as I've seen from my polls that I give to the Erasmus students, this is not the case in European countries. I get a lot of answers that students are actually not in contact with some human rights courses to the very end of their studies in their respective faculties across Europe. Of course, then we have, I couldn't overemphasize the importance of comparative constitutional law for understanding European human rights law, and of course, understanding concepts such as European consensus, and of course, understanding the scope of margin of appreciation and so on. And as I said, understanding the legislative procedure in the national context is relevant, and in my opinion, really strong basis with the introduction to the law courses are more or less very much beneficial. As you know, lawyers do not get some diplomacy courses, but I believe these skills may be acquired independently or in some other settings. So I will stop in a few seconds, but I would just like to say that there are some limitations by some professionals of the Ministry of Justice that there is not much scholarship in Slovenia. I would respectfully disagree. as Veronica said and Jerne already mentioned, I believe Jerne is the one that actually did very extensive research in that regard. But I have to even add up to this. At least myself, I mentored and supervised a lot of LLMs and bachelor theses that go in this direction. Actually, could be a valuable tool for Slovenian professionals. But in any way, we have access to global teaching materials and, of course, specialized art from this. So in this international environment, I don't see this as a problem. We have it, and I would like to maybe mention one another thing. In a few months, I believe one of our PhD students will actually defend his PhD thesis, if everything goes well, with the title "Problems of Implementation of the Judgments of the European Court of Human Rights," which is actually something that Veronica and Ula are actually trying to present for the Slovenian. And by saying so, I would like to thank you once again to both of you for a very wonderful and very succinct presentation of the situation in Slovenia. Thank you very much.
Super. Thank you so much, Sasha, and thank you all three for your comments. I will try and address them. I'll choose a few to address them, but I wanted to first of all say to our people who are still online with us that if you have any questions, please, you are welcome to, I think, put them in the chat or in the Q&A. You might also be able to raise your hand, but I'm not sure because I'm just I'm not the host, I think. So if you could put them in a chat on Q&A, we'll definitely turn to them as I go through the comments that our discussants made. So I wanted to say thank you to all three. I think that's really wonderful, and you've given us a lot of food for thought really on what to think about. So there are a few things I'd like to sort of pull out of the different interventions. So in relation to David, I think David asked a really key question that sort of relates, I think, to your article, but you asked about the political environment, right? Or the moment in which, or a window of opportunity in which this kind of change on the legislative, executive level was possible to bring about the project group and to really change things, sort of facilitate implementation and compliance. And I think so one thing to say is that before 2015, the compliance issues seem to have lived with the State Attorney's Office, who's also the government agent who presents Slovenia in front of Strasbourg. So you had the body that litigates also seemingly responsible for compliance. And I think that kind of joint responsibility or function in the same person may have been a difficult thing to navigate. But what came out of the interviews and what I think came out of the presentation that we did is that there was a window of opportunity in 2015, and everyone that we spoke to linked it to a person. And that person was the then Secretary of State, the Minister of Justice, Goran Klemenčič, who, from the interviews, it became very clear that he had made compliance a priority, right? That for him, this was a priority and that cases had to be closed. And I think he organized a group around himself that would facilitate that. And when people spoke about him, they spoke about his charisma, they spoke about his energy and how this was a priority. And so, I mean, we include this to a certain extent in the report, but what became clear really is that you can have a person in a place of power that can make things happen. And I think our feeling currently is that even with the change of government, so even after the minister leaves later, and even after other people come into power, that group of people who now have this responsibility that currently takes about maybe, I don't know, 20% of their work, but they also do other things, so that they are still free, right? So that they're still civil servants responsible for this area. And I think giving them that kind of responsibility and independence seems to have been really important. But you had to have someone to trigger this. So I think that was really important. The other question that I think both David and Jirne raised was the issue of what is compliance. But also, let's be honest, what is implementation, right? And those are the questions that we are, I don't want to say struggling with, because we are thinking about them, but there are so many ways you can go about it, right? So statisticians and studies up until this moment have really said that they will take the decision of the responsible body, which is the Committee of Ministers, as the last word that something has been complied with. We have issues with that because of a number of problems that Jirne and David both mentioned. And so we said, we're going to look at compliance in the way that the Committee of Ministers thinks about it, but we're also going to go a step forward and talk about implementation. And we're going to think about implementation as a situation where things prevent future violations, right? So we are looking at the decisions of the European Court of Human Rights, not only as a dispute settlement body where, you know, you just want to sort of, is this enough? Yes, it is. But we're looking at it sort of from the Inter-American Court of Human Rights, who's really thinking of its function in a different way. And that is, let's change Latin America, right? So if that's what we're thinking about, systemic structural changes around Europe, then we need to go beyond this compliance. But these are not, I want to be completely clear that these are not notions that are predefined. They're not notions that anyone knows what they mean. And so they're sort of open for us to interpret. And so we've decided to interpret them this way, but also to leave room for discussion on what they are and who should decide them, right? And that brings me to the points Jirne is raising, which is the Committee of Ministers an appropriate body, right? So in our study, obviously, we take the committee's word as the last word in terms of compliance, not implementation. And as Jirne said, it's a political body. It's a diplomatic body where it does get legal advice from the Department of Execution, but really you've got diplomats sitting around. At certain points, you've got ministers, right? Secretaries of state sitting around the table. I don't want to say negotiating and bargaining, but you know, that's probably, there's probably a bit of that there as well. And so the question there is whether you have this gap, or what in French you would call décalage, between the European Court of Human Rights, which is a judicial body, and then a political body deciding what's enough to comply with this judicial decision, right? And how they do the two gel together. And the reality is that they are not sure how they gel together, right? Because you have a number of decisions like Burmick, like very controversial decisions where the European Court of Human Rights says, we're not going to decide on this. This is a compliance issue because there are so many cases, we don't want to deal with them. And then the Committee of Ministers says, well, we're not going to deal with it because it's too politically sensitive. So you've got areas where things sort of escape any supervision. And I think that's highly problematic. So one of the aims of the project is also to think comparatively to other systems. So in the American Court of Human Rights, it's the court that decides when its judgments are complied with. So it's a legal judicial decision. And so we are looking also to what extent the Committee of Ministers prematurely closes certain cases. And that has happened, and that is happening in relation to a number of countries where they close the case, and that case comes back to the court in a few months, in a few years, et cetera, et cetera. And so the European Court of Human Rights is then resolving repetitive cases over and over again. So it's something we're very aware of. It's something we are thinking about. And it is also something we're thinking in terms of remedies. But one of the things that's also come out of discussions I've had with barristers is that often you will have to step out of the international system to get your decisions enforced. And so, for example, for countries like Russia or Turkey, what has had to happen is you've actually had to, you know, sue the country for its property in a third country to get your European Court of Human Rights decision enforced. And that means that the processes, not in Slovenia, but in a number of countries, these processes of implementation compliance are really failing. It also means that the reputation or the position of the court is being undermined consistently, right? And in that context, let's say that the pushback that the court is currently getting, also from domestic courts, is not helpful, right? And so the story we're getting from Slovenia is a really positive story of the executive and legislative branch. Now, I agree with Sasha that there might be individuals who still reject certain decisions, but let's say on an institutional level, you do have a very important shift in attitude, in priorities, in how it presents itself on international level that you may not have had before. Also how it speaks, how confidently Slovenia speaks and presents itself at international level. But you have a different story in terms of the judiciary. And I think what I would say is that when it comes to courts, we need to understand they're independent. The executive branch doesn't have much power to really tell them, apart from giving them judicial training, but to tell them how to make their decisions, because that would be interfering with their function. And the most that the executive branch or the project group can do is report what they have done, but that independence really limits you to what you can do. So it's for each judge, I think, or court to decide how they want to position themselves vis-a-vis the European Court of Human Rights. And I think it's really important to underline that the European Court of Human Rights is not negative or resentful of judicial dialogue. There have been, you know, the German Constitutional Court in Solange, you had Kadi, you had a number of other cases where the court, like the UK Supreme Court, where the court has accepted the argument of domestic courts and has taken a step back in certain areas because it felt it wasn't, perhaps that it wasn't super qualified. So I think judicial dialogue is a good thing, but it needs to be informed, reasoned, and respectful. And I think that is an important element. And it needs to take place through judicial decisions, which are reasoned rather than in other ways. A question of internalization is a problematic one. So when do we accept something someone else is telling us? I think it's problematic, especially in today's world, where we feel if a foreigner tells us something, you know, a number of people will be a priori against it because it's a foreigner who said it. So one of the things we will analyze in our textual kind of approach is what kind of words trigger what kind of response both from government agents or from government institutions, but also from courts. And so we're trying to really find whether or not courts sometimes mirror language of the European Court of Human Rights, and how then we can find these values in domestic decisions. That would be, I think that's a really interesting thing to do. And then final point I wanted to make is, I think Sasha is absolutely right that really what, you know, Ula and I and our team are dealing with are really issues that relate to when things have already gone wrong. So that we should do everything we can to prevent human rights violations happening. But we can also, I think, understand these cases as flags, as little fires to tell us where the problems are. And the problem is if we take these little fires as just a little, you know, kind of, I think David used the word minimalist compliance, right? If we just want to take them out for a bit, but still leave the little, right, bits burning, they're going to come out again. And so if there is a fire, there is a problem, let's work together to fix it. And I think here, I think a lot has been done in Slovenia, but I think there is still room for other actors to engage in this process of active compliance. So I'm going to stop there. I'm going to thank you all very much for your comments. And then I'm just going to see if there's anyone in the group who, from our attendees, who has any questions for any of us, really. So I would invite any attendees to write us in the chat or in the Q&A. We have one question, which is regarding the current COVID situation, and what do we think about human rights violations in that context? Guys, does anyone of you want to sort of think about that or address that? David, do you have anything in the Czech Republic coming through the courts on COVID cases?
In the Czech Republic, there has been quite some litigation before the administrative courts as well as before the Constitutional Court. But I must say that the Czech Constitutional Court, until very recently, tried to avoid taking stance on any of those issues. So they basically dismissed many cases on procedural grounds for the lack of standing or because this extraordinary measure, its time already elapsed and so forth, or that the litigation was raised by someone who could not challenge it directly before the Constitutional Court. So they try to dance around it, which is interesting because then the primary role of interpreting the Constitution is at the administrative courts, because they have to sort of decide on whether a certain issue was adopted according to the Constitution, and therefore it may serve as a legal basis as a sort of preliminary question in the dispute. So we have an interesting tussle right now between the municipal court in Prague and the Supreme Administrative Court, but there has not been any like final solution of this. And the only case which came out only like a week or so ago from the Constitutional Court was about, discriminatory closure of small businesses when the big businesses could have been open. But that's the just very first swallow that came out from the Constitutional Court. We will see. We have some bigger issues right now because the Czech Constitutional Court struck down the Czech electoral law, and we are facing elections this October, and no one really knows according to which rules. So that's right now like the hottest topic of the debate. And of course, given the fact that it's a COVID era and all sorts of other things, it's extremely difficult and interesting. I have some other comments on your rejoinder, but I will stop here, and if there are no other questions, we can, I guess, return to that. So
super, thank you so much. Do we have cases in Slovenia, your name, Sasha, on COVID? There was something, no? There was the children.
Yeah, we have several ones. In comparison to the Czech situation, our Constitutional Court was more active. In some ways, in general, we may say that, of course, it deferred and it left the government with quite a wider margin of appreciation what to do in an extreme situation, especially concerning the limitation of freedom of movement that was limited to the municipalities. However, in some other cases, the Constitutional Court was much more involved in particular by pushing some procedural standards of constitutionality, how legal acts should be adopted, published, and so on. It was very much strict. Some commentators were against it, that the court goes too far, but I would say that it was still correct on the issue. And of course, as the David said, for the Czech Republic, a lot of courts cases are pending before the court, and now we see that the actions from the civil society, small enterprises, are much more consistent, more well-prepared, systematized, and probably we will see some, let's say, even after the crisis is over in terms of epidemic, we will see still this, let's say, legal traces, legal tales of the post-COVID resolution of disputes.
Yeah, thank you. Nate, did you want to add anything?
Yeah, there have been many cases, as Sasha mentioned. Many decisions are expected. I remember one recent dissenting opinion when one of the judges was complaining that Constitutional Court has been turned into COVID court. So there's around over 100 cases pending before Constitutional Court concerning this situation, particularly concerning limitations on restrictions on freedoms, assembly, movement, and so on. And I expect that the court will deliver further judgments in in the next couple of weeks, couple of months.
Yeah, and I think from the European Court of Human Rights stand, I think we're going to wait for a few more years probably before things are going to come to that level after domestic courts have dealt with them. So I think we have no more questions, and I don't want to keep people on the line. So I just want to thank you all for your contributions, for your comments, for giving us food to think. And also want to say thank you to Ula, who has done really the majority of this research, and we pulled it together with interviews and other things. So thank you all very much, and thank you to our attendees. And I hope you all have a lovely day and get to read our paper either in Slovenian or in English. Thank you.
Thank you, Veronica.
Thank you very much.
Bye-bye.
Bye.
Thank you very much.